All right. Look at everybody coming in. Hi, everybody. I love this event. It's so well attended. Makes me happy. All right. I think everybody is in. Good afternoon. Welcome to Grand Rounds. I'm Kristen Ritchie. I'm an attorney with the Boca Raton Practice Group. I'm filling in today for Liz and Kelly, the co-chairs of Grand Rounds. They couldn't be here today, and I'm so happy to be here with you guys. We're pleased to present the October session of Grand Rounds, a monthly lunchtime training showcasing a different Florida collaborative practice group. The first portion of the session will be a group presentation, and the balance will be a discussion period where we'll troubleshoot and brainstorm solutions to the unique problem presented in that session. If you have any questions during the presentation, please place them in the chat and we will kick off the discussion period with those questions. Once the Q&A session begins, please raise your hand by clicking the bottom of your screen in the reactions box when you would like to speak. Our next Grand Round session will be held on November 19th, and it features the Northwest Florida Collaborative Law Group. The topic will be military divorce issues, and it'll feature Dr. Nita Koneman, Attorney Kim Reed, and financial neutral David Smith. Be sure to mark your calendars now. Thanks again, everybody, for joining us, and thank you to our presenters. I am so happy to now introduce you to first Banda Nadeau. Banda is a collaborative family law attorney and Florida Supreme Court family law mediator in Jacksonville, Florida. Banda established her own family law practice in July of 2020. She is president of the Collaborative Family Law Group of Northeast Florida and an active member of the Florida Family Law Inns of Court and Jacksonville Beach Bar Association. We also have Susan Hartman. Susan is an attorney, financial advisor, certified divorce financial analyst, and a Florida Supreme Court family law mediator. Susan specializes in retirement, tax, estate, and comprehensive financial planning. She is secretary of the Collaborative Family Law Group of Northeast Florida and an active member of the Jacksonville Beach Bar Association. And with that, I'm going to hand it over to our presenters. Banda, have at it, please.
Thank you, Kristen. Hello, everybody. Thank you for joining us. So our topic today is titled The Downward Spiral of the Case and What Can Be Done to Save It. So I'm going to start out with a fact pattern, and I'm going to take a little bit of a different approach and start out with a little bit of it and then ask some follow-up questions as we go along. But this is our fact pattern. So Jack and Jill have been married for less than 4 years. They have 2 children, 3 and under. They are both in their 30s and have professional careers. Just before they were married, Jill received a PI settlement and entered into a prenuptial agreement to protect her settlement. The prenuptial agreement also included a mutual waiver of spousal support and attorney's fees. Jill then filed a petition for dissolution of marriage approximately 2 years later. 2 months after she filed the petition for dissolution of marriage without a collaborative participation agreement, Jack and Jill then entered into a collaborative law participation agreement. So it started out, they filed it as a litigated case, and then 2 months later, they decided to merge into the collaborative process. Now, the attorney who was initially representing Jill turned the case over to another attorney in the same firm to take it over as a collaborative attorney. And after the 4th team meeting, Jill terminated her attorney's representation and retained another collaborative attorney. So our first question is, can one attorney in a firm who started the case as a litigated matter turn it over to another attorney in the same firm to take over as the collaborative attorney? Anybody have any thoughts?
I believe you can, so long as it's screened and it's segregated that the other attorney doesn't know about it. So I believe you can. Now, if the other attorney, which you said the other attorney doesn't know about it? The original one from the firm that they're turning it over, and that he has no say on that case anymore. So it's been exclusively shielded from everyone else.
Okay, at the firm. And
Yes.
Okay.
Yes.
All right. And what are the procedures? Does everybody know the procedures when one collaborative attorney is terminated and another is substituted?
Well, Banda, sorry.
Yes.
Elaine, I just interrupt 1 second? So
Sure.
any litigation attorney, I believe, can always convert to a collaborative case. You can be the same lawyer, you can be a different lawyer, you can be the same lawyer in a firm. You can always convert to a collaborative case. But I don't think there's a conflict, because once that collaborative participation agreement is signed, it would, I believe, bar the entire firm from ever going back. So as Jeffrey Wasserman says in the chat, yes, that's fine. You just can't go the other way. That's that question about the same firm.
Okay, thank you. Does anybody know the procedures once a collaborative attorney is terminated and then another collaborative attorney from a different firm comes on board?
I believe it's supposed to be in writing that they're discharging themselves from that position, and then there has to be a new engagement with a new collaborative agreement, and that all the parties involved in the collaborative process must consent to it.
Correct. Under 12.7453, the attorney who is terminated should always give prompt notice to all the other parties that they have been discharged, and the unrepresented party now retains their successive collaborative lawyer. Another participation agreement is signed and amended. The parties consent to it. That needs to be signed. There's a reaffirmation of the collaborative law participation agreement that needs to be signed. So all of that, and also a stipulation of counsel needs to be signed as well, because that was an issue that we had in St. Johns County with a case where the judge, it was stayed by the original firm, and then we filed a substitution of counsel, and I don't think the judge was new, and I'm not sure if she knew exactly what to do because the case was stayed. So I followed up with a letter to the judge and quoted the rules, and that was, I think then she understood and she signed the order substituting the counsel. So now it's back stayed and we're on the case now. So going into more of the facts, so a couple of months after collaborative attorney 2 started on the case, Jack was supposed to meet Jill and the children for an outing, but he canceled. Jill subsequently learned that the husband, or Jack, was spending time with his new girlfriend instead of with her and the children. Jill sent numerous text messages to her attorney throughout the entire weekend, saying now she wanted to litigate the matter because of what Jack did. The process was derailed for a while, but with the effort of the team, the case got back on track. Now, the parenting plan at this point was prepared by the neutral facilitator and signed by Jack and Jill. And based on Jack's schedule, he would have the children every other weekend from Friday through Sunday, and 2 weekday overnights consisting of Monday and Thursday, alternating each week. So by the end of the 16 meeting, the team had worked through equitable distribution, and the spouses had initialed the child support worksheet, an equitable distribution worksheet, just confirming that they agreed with the way assets were divided, and also another sheet about the personal property. So everybody was on the same page as far as what we were going to do when the actual agreement was drafted. So we then got to the point where the collaborative marital settlement agreement was drafted. So at the next 17 meeting, the team would review the proposed agreement. Unfortunately, everything went south again when Jill learned Jack was drinking and leaving the children with his mother, who happened to live with him, while he was supposed to be exercising time sharing with the children. Jill then got very upset again, sent another barrage of text messages to her attorney over the weekend, wanting to terminate the collaborative process again, and demanding that Jack now only have time sharing, and threatening to suspend his weekly overnights and just wanted him to have supervised. So our next question is, what boundaries should all the professionals place with a client so the party to the different spouses, so clients don't have an unrealistic expectation of, I'm going to text all weekend and I want you to respond back to me ASAP. Does everybody allow their clients to text them? I'm trying to get on.
Yes, and I finally had one client today that I was like, okay, we need to set boundaries. 5 emails and 7 texts in 3 hours goes beyond those boundaries. But really, when I just pointed it out, she was like, okay, I get it. 4 texts later, okay, I understand now. Yeah.
I mean, I have a rule of no texting just because I tell clients there's no way for my office to be able to monitor those communications. They're very hard to preserve.
That's what I said, the same thing. I can't save it. And you want me to save these? Not really, but yes, that was a good excuse.
Yes. I've actually used that before too now. Yeah, Randy. Oh,
I got it. Thanks.
Okay.
Thanks for doing this.
Sure.
As a mental health professional, we have a good excuse to and ability to set a boundary by telling them it's not HIPAA compliant to text us and that they're not allowed to do that. And the other thing is, if they do that too much, I charge them and then they stop doing it. So, so that, you know, there's 2 ways, but it is really not HIPAA compliant. So for any MHPs on the call, we're not supposed to be doing that. Sometimes they can do it. They can do it if they choose to, and if you allow it through WhatsApp, but that becomes a S show. So I don't recommend it. And like you're saying, I like to have a trail. And so email.
Yep.
Yeah. But they do get
go ahead.
They do get offended, you know, but they get offended about a lot of boundaries, but I think it's our job to set those boundaries. So.
I'll just add, I've just gotten away from giving out my cell phone at all, except in limited circumstances, because it sets an expectation that you're always available. And even for our mental health, we can't be always available to everybody. We need our time too. So I think if you set some good boundaries with that, as long as you're also responding to phone calls, you know, and emails, or having someone in your staff doing it pretty quickly. I haven't had clients complain about not having access. They do complain if you give it and then cut it off, but I don't have them complain if I don't give it to them in the first place.
I think as an attorney, if they're texting you something and it's it's an emergency or very important to them, I'm very careful. I don't really write anything. I mean, just a generality, and they would have to email me and set up an appointment to speak, because I'm not so quick to have anything documented in writing in Texas. So I'm very careful with that.
And I know sometimes I have too. If they will text me, I'll just wait and then send them an email saying, I received your text, but as Randy had pointed out, and I just happened to be on this website, which is a bunch of women attorneys, and they were all discussing this about giving your cell phone out and texting back and forth. And, you know, I thought, oh, this is great. Just like Randy had said, we have to preserve all of this, and we're not sure if all the communications are being preserved on a cell phone that can die, crash. So, but yeah, in the beginning, a long time ago, I used to, but I've learned.
Vanda, can I jump in for a minute?
Absolutely.
All right. I'm a firm believer that everything starts with the retainer agreement. And this is an agreement between you and your client. And I don't care if it's between the attorney, the MHP, or the financial professional. You have an agreement with the client and you set the boundaries within the retainer agreement. And to discuss these things will give people ideas on what should maybe be included in their retainer agreements that haven't been included up to this point. But it should all be set out, and it should be set out as to whether or not you charge for these things and whether you prefer email versus text and things of that nature, so that your relationship with your client is always going to be established from day one. Now, if you have to, tweak it to some extent after the initial retainer agreement, that's fine. You can do that by email agreements, but include all of these things in the retainer agreement. The other thing, Bandit, that I wanted to point out, in addition to the rule that you're citing, okay, which is excellent, you also have the FACP ethical standards that we must look at in connection with the questions that you're asking concerning attorneys coming in, going out, whether they can go from a collaborative process into a litigation process or from a litigation process into a collaborative process. The typical litigation to collaborative is when somebody files a vanilla simple petition, okay, hoping that the other spouse will hire a collaborative attorney, and then they convert the whole thing to collaborative and abate the litigation. You're allowed to do that, but you cannot go from collaborative to litigation. There's an absolute bar under the ethical considerations of FACP and IACP. You can't do it.
Thank you. And yes, that should all be, I've tweaked my retainer agreement so many times just as I've gone along and learning. It's like, oh, okay, maybe I need to add that. But I feel like even though I have them initial each page, it just goes right up with their heads. So, sometimes you have to send the retainer agreement to them again and go, okay, would you kindly reread this just to refresh your memory on what you agreed when we entered into this? So yes, if you have it all in there, then you're covered. So anybody else have any comments? Or
I would just agree with you, Banda, that you have to keep revisiting it because they forget and they're emotional. So I think we have to remember that, to them, I think somebody said, if it's really important, you have to be well, everything's really important to them when they're going through this. So it could it could render us working, 24/7. And I think even in mental health, we're more inclined to respond, immediately, but it can get out of control. So I think we have to keep revisiting it. I think you're raising some really good points. And Jeff, you're just Mr. Ethics. It's just, you're just Mr. You're a walking textbook, a manual. It's great.
All right, well, I'm going to move on. Now that Jill has found out that Jack's been out again when he's supposed to be home with the kids, now her trust is completely lost. Of course, Jack realizes that he's exercised bad judgment once again, and he reached out to Jill to make amends and promised to be better. They spent the day together with the children, and she decided to allow him his overnight time sharing again. So the team at this point, they thought they were in a good place to finalize the collaborative marital settlement agreement. Jill agreed to stick with the collaborative process. However, she decides now she's going to terminate the neutral facilitator because even though the parenting plan was in place, she felt like the neutral facilitator did not take her seriously and was siding with the husband. She also decided that the husband should have less time with the children, even though the parenting plan was already signed and initialed. Also, Jill wanted the husband's family members to be removed from the list of approved people, that they had both agreed to watch the children in the event neither one of them could. Jill also requested the marital home be sold, although they previously agreed Jack could maintain the home for the sake of the children. And after Jill's attorney suggested she not take the home away from Jack because, honestly, it's punishing the children, not Jack. So she agreed that Jack could keep the home. However, she wanted a higher value assessed on the house. And she wanted Jack to give her cash for this, for her equity, as opposed to taking it out of his 401k, which he had been prepared to do. And Jill knows that Jack doesn't have the cash laying around to actually give her cash. So now Jill is, I don't care. He can just cash out his 401k or find the money wherever he can, but I want cash. They next agreed in the original that Jill would keep her wedding and engagement ring for the children. Now Jill doesn't want the rings and is demanding that Jack just give her cash for the rings. Now, as a side note, throughout most of the collaborative process, Jack claims when Jill needs anything, whether it's diapers, food, her apartment cleaned, errands run, even sex, he was there at her beck and call, although he knows he needs to attach himself. Jill, however, claims that she moved out of the home shortly after filing the petition because Jack was sexually forcing himself on her. She also claims she did nothing, that Jack has done nothing for her except run diapers over every now and then when she tells him she needs them. So going back to this part of the fact pattern, can one spouse terminate the neutral facilitator if the other spouse likes the facilitator and wants to keep her? Yes, Fraser. Okay. If one spouse terminates the neutral facilitator, can the other party still communicate with that neutral facilitator?
Banda, I don't think so. I think both need to be on board. I agree with what Fraser's comment is. The demands of this woman, the thought process, the way she's approaching her concerns is very unilateral kind of communication. And to me, that indicates like a need for client management. And I would circle around with the attorneys to see how to address that with her and bring her more into the fold of interest-based and help her recognize that her approach, the consequence of her approach and what it looks like on the other side. But to your question, yeah, I think that both parents need to be on board, or spouses. So that's a real issue for the facilitator to deal with. And ultimately, if the client, so it'd be partly addressing client management, their approach, their thought process to collaborative, to the interest-based versus positional, which is how she's presenting, is very positional. And do our best to kind of bring her back into the fold and recognize the benefits of an interest-based approach. But ultimately, if she's like, no, you're out, I don't want you as a facilitator, then I'm out. Because you can't have one parent okay and the other not okay, and that would suck. But but I would try to do my best to triage that with the professionals, and not for my own benefit, but for the benefit of the process, right? And there might be reasons why she wants me out. I think you gave some kind of detail. There was some sense of not neutrality with the facilitator. So I, whether on my own and or with the help of her attorney, would try to address that with her to see if we can help her recognize my role and what actions, identify from her perception what actions I took that were not neutral and versus neutral, and to kind of help reorient her to what my role is and why I do things the way that I do as a facilitator in the process. So I would do my best to try to address those concerns that she's presented. And yet you have to also respect where the client ultimately is at in their decisions. But I couldn't be there.
Actually, Tammy, I think that's a perfect example where the collaborative team has to come together to support each other. So in order to re-educate the client again on the importance of having you as the facilitator on board and why you came on board from the inception, because that's where we come into play so that we can show the importance that we need you in order to get through this process. So rather than putting it on your plate for you to explain, I think it goes more to the attorney to support you to reinforce the importance of it.
What if
Banda?
Oh, go, yo, yes.
Ultimately, neutrals are in the process with the consent of the clients. If one does not want a neutral to be in, then that dispute has to be resolved. And ultimately, each client has the power to terminate the process if they don't like who's in the process. And I've heard about neutrals being replaced. I almost had that once in one matter. And also getting rid of a neutral and proceeding without the neutral, which somewhat happened to one that Randy and I had. And if that person is terminated, then the clients cannot discuss anything with them because the process is confidential, and that can't be violated.
A good point, Randy.
I also think to everything that's being said, and Tammy, I agree with everything you said. I think there's an issue of then alignment and trust, right? So if a client isn't comfortable working with me, and then I try to insist that they have to, there's going to be conflict there, even if it's covert. And so how do we facilitate a comfortable, trusted, peaceful resolution if this client and this neutral are even covertly at odds, right? So yes, like Bob said, you try, and like Tammy said, you try to talk it through, you try as a team. And I can say, even in a matter we just had, the team really worked with the clients on, this is about you, not about her, and let her help you. And if you'd only let her help you, she could be helpful. Da, 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 da. So the team did come together, to your point, Candace, and support. But this person was adamant, and actually, he ran the rounds of firing every one of us on the team as we went through it. He would have fired Bob too, but Bob wasn't his attorney. So, but that said, I think you then have just an escalated conflict, which isn't what we're about. So Tammy, like you said, it's taking one for the team, right?
Yeah, you have to meet the clients where they're at. There may be something they're missing, and so you want to explore that, but you also have to respect what their needs and interests are and where they're at. Right. So yes.
All right. What at this point in this particular fact pattern, given although the parenting plan was signed and initialed, now Jill is wanting a lot of things redone. What are the thoughts on bringing in, and the client is adamant, I don't want this neutral facilitator, then at this point, would you want to bring in another neutral facilitator to try to diffuse and help bring everything back together? Or should the attorneys just try to carry on and hopefully get Jack and Jill back where they were before the incident? Whichever one.
It's okay, Tammy, we're speaking the same language, so go ahead.
I mean, at least, right, okay, so assuming I'm out, but what would the rest of the team do? I mean, just at least one of my thought processes is that I would have to reassess where we're at with the client. That happens sometimes in therapy, in individual, we've got to certain places and then all these new things come up, or they've made so much progress and yet the client's still showing up. Those are examples of when would you reassess, is when you're kind of where do we go from here? that's when you reassess. And so at least I would say that to the team is it would be, because this woman has kind of taken everybody to a left turn. Right. So where are we right now and where do we go? At least I would say that is something to answer your question.
Yeah. And just to piggyback on that, I'm thinking that, you know, it sounds like the question of who's driving the train again, you know, and it sounds to me like this woman is, you know, she's derailing and, you know, she's in control basically of the process. And that's, you know, that's another grand rounds, and it's so tricky, but, you know, I like Bob's idea, bring in another facilitator, please. You'll probably find you'll get the same, you'll have the same dynamic unless it's someone who agrees with everything she says. So, you know, but why not try, you know?
Yes. I was looking in the chat, is Jill ready to move forward? Good question. She might be. What if it's a scenario where Jill claims she's ready to move forward, but maybe in reality, since it's getting so close to everything being finalized, that now she's having a knee-jerk reaction and just having second thoughts, and no wonder Jack was drinking. Yeah. But so I don't, you know, in this fact pattern, I almost think it might be helpful, considering how everybody thinks everything is going well, then all of a sudden Jill just blows up, and now the whole team is, okay, this is just came out of nowhere. Now what? And then you get her calmed down and you think everything is fine, and then something else blows up. Oh, that was Betsy. What did Betsy say? Great idea.
Betsy.
Oh.
She said to bring in like another that's a creative idea and not something we do in South Florida, the culture of our collaborative groups, but to bring in another facilitator. So to kind of onboard a 2-coach model, which would be kind of a cool thing if they're open to it, and it may help neutralize and address what's going on for her. Because what I'm hearing from you, Banda, like another thought I was having is she kind of needs like a come to Jesus conversation. You know, like, what's going on? What are you doing here? And I was also thinking about that, the BATNA, you know, the best alternative to like as part of this come to Jesus, you know, how are you benefiting here, Jill, with what you're doing? Because how is this where, you know, and what does it look like on the other side in litigation, you know? So just to help her recognize and take a look, an inventory of her behavior, and what is her ultimate goal with this, the left turn, all the left turns she's making. So
how likely do you think it is, Tammy, she can look at her own behavior?
Well, that's why I like Betsy's idea of a 2-coach, you know, that's a creative thing, especially for us in South Florida. That's not typical. I've never been a part of a case or heard of a case in our Florida community with a 2-coach model yet. So I say creative, but I like the idea, and it could really be a possibility that's helpful for Jill.
We use 2 coaches on our pro bono cases sometimes because we have lots of free labor. But the problem, as I see it, bringing in another coach, although I do think it's a great idea, is that if she's, again, it's the being at odds with the other person. So then you have alignments, right? You have her and her, you know, aligned coach, which is really the title that Peggy Thompson gave it. And then you have the husband and that aligned coach. And I just see that as being very divisive because they didn't come in together. Do you know what I mean? I don't disagree. It's a great idea. She probably does need that support, but she's already got bad feelings about that other person. So no matter what that other person says in that collaborative meeting, it's going to be, I would think it's going to be dismissed.
Has anybody thought of the idea that maybe Jill isn't so stupid and so problematic because of issues that we've been discussing, and is really playing her husband for every single ounce of blood she can get before the process ends. And he wants to stay in the process because he's got to get out of this marriage desperately. And he knows if it goes to litigation, it could be 2 years down the road that he's still married to this woman. Anybody think about that possibility?
Yes.
So I was going to take a slightly different angle. Sometimes when people are in and out and taking turns all over the place, sometimes it's not an issue that really we can deal with in the collaborative team, and it may be a therapy issue. And I'm wondering if I would be inquiring and be very curious about that, if she's involved in any therapy or if she's not, if that would be a reasonable referral to help her deal with her issues and concerns and maybe ambivalence and all that. I've even, with the knowledge of the full team and obviously all the appropriate releases, have a case with somebody who has a history of significant mental illness. And we thought it would be best that I make contact with the therapist just to keep an eye on, make sure that her mental illness was not rampant at the moment, and that she really was in a place where she could problem solve, have informed decisions, because she had some history of thought disorder and whatever in the past. So sometimes I think a relationship with somebody outside the process who understands the process may be a benefit when you feel like you're spinning in space and the team isn't able to get it all sorted out. Just a thought.
Jeremy, I see your hand.
Yeah, so I agree with everything that everyone has said, but I would suggest that getting Jill to an individual therapist based on everything we've seen is probably not going to happen all that easily, particularly without the help of a facilitator or a coach, someone within the process who she does have more trust with. And so I think we're assuming, because we're all saying, oh boy, Jill is so difficult, she must be the problem, it's not the neutral facilitator. You know, there could be just a mismatch between them, or maybe the neutral facilitator just isn't the right one for them. So I think all of these ideas are great, but I wouldn't jump off the tracks quite so quickly. I think if she's not happy with that neutral facilitator, but she's willing to have another neutral facilitator come into the process, I think that's certainly worth trying before going to anything more extreme. I have done the two-coach model, and in this case, I think that is something potentially to consider if you're not able to succeed with a second neutral facilitator, because that person really will be still in a coaching role, will be able to help try to connect her with the therapist, but still will be able to work closely with the team. So I think there are a lot of options, but I wouldn't go to anything a little bit more creative or extreme yet. I think if we just stick with the methodology, neutral facilitator or neutral coach, the process works. If it didn't work with that one, there's a good chance it could work with the other one.
Sheila, did you have your hand raised again? Thank you, Jeremy. Anybody else have any comments? I can't see everybody's. Roxanne. I think I saw Roxanne.
Yeah, thank you. I had to get off.
Okay, sorry.
Yeah, I came in late, so I've been very quiet, not knowing related facts. I also think that having her see an individual therapist would be helpful, particularly if she's feeling that that person is going to understand her level of frustration and upset with the team. I think the issue would be who's the appropriate person on the team to make that recommendation, that it has to be the one person that she feels is somewhat in her corner, so that she doesn't see it as everybody's saying that she's the problem, as much as let's see if we can figure out what to do to kind of help with this. So for me, it would be the way it's presented and by whom.
Let me throw another twist in here. What if Jill was told that it was suggested that she probably needs some therapy, and she was offended and said, I'm not the problem?
I think, you know, I'm listening to that. I'm sort of having this visceral negative reaction to having two facilitators for some reason, because I feel like it's going to perpetuate the dysfunction or the manipulation. That's kind of to Jeffrey Wasserman's point. However, let me just make sure I'm clear here. I think, you know, with the coach, you could couch it to her. The facilitator should be the one to do this, to couch it to her to say, look, this is very overwhelming. This is not your wheelhouse. This is law. You're saying goodbye. You know, you're getting divorced. This is huge. And I'm going to suggest, I'm here for both of you, but I'd like for you to get someone to support you who's familiar with the divorce process, who's familiar with, you know, this arena. So you have somebody to support you just for you. And then that coach, you're kind of handing them off to somebody capable to maybe almost become like the lion tamer in the collaborative process, because she's a handful and she needs extra guidance, support, boundaries, you know, structure. And that may bring her anxiety down. Or if it's just what Jeffrey's saying, she's just out for blood, you know, to maybe slowly try to work her into a place to get the job done. And then at that point, they're going to establish their connection. And then the coach can say, look, I really recommend therapy, not because there's anything, you know, inherently psychologically wrong with you, even if there is, you know, but this can take years sometimes to say goodbye to a family psychologically, and you're giving yourself, it's a gift to yourself, you know, something along those lines.
Mike, thank you. I agree. Anybody else?
Yeah, I just want
Jeremy. Yes.
I just wanted to add two quick notes. I'm a real believer in the neutral coach model. I practice it, I teach it, but I would say that here in Florida, we are so embedded with that approach, and it's partly because of our own doing, because we're believers in it and it works, that we, I think, are hesitant to consider the two-coach model. And I think that's a mistake, because I think it is another tool in the toolbox that sometimes works better for certain families. For this family, it might work. Keep in mind that the two-coach model, those are aligned coaches, so they are not two facilitators. They are two aligned coaches who then work together, and they sort of choreograph their involvement. So it's not really someone in your corner, and we're just going to fight it out. It's someone who is going to help coach you, someone who's going to help coach you. And then those two aligned coaches work together along with the team to help manage the process. So I think we should stay somewhat open to it. The other thing I just wanted to mention is, as we all know, whenever we are encouraging one spouse to see a therapist and we notice any resistance, what do? We always talk about each spouse benefiting from seeing a therapist. And while that doesn't always work, I had an example that happened just yesterday that kind of refreshingly highlighted this. We have a wife who very much needed to see a therapist, and she was resistant for certain reasons, but nonetheless, she was agreeable to see a therapist. But then she said to me, well, why doesn't he have to see a therapist? Because he really needs a therapist too. And I was quite sure that when I spoke to him, he was going to say, I don't need a therapist, this is ridiculous. But I said to her, you know, everyone can benefit from a therapist, let me talk to him. And I called him and I said, listen, you know, what would you think about that? He said, oh, I think that would be great. I would really benefit from seeing a therapist. Can you give me a name? And I gave him a name, and he went ahead and called that therapist. So sometimes we have to just give people opportunities and not assume that we know how they're going to react. And again, I think the idea of offering those resources to each of the spouses, ultimately they get to decide. But I think it's worth offering it. I think everyone can benefit. I mean, most collaborative cases I'm involved in, I really need a therapist of my own, because I have to deal with, you know, with lawyers and accountants and all, and that's very, very stressful for me. That was a joke.
Oh, well, I mean, when I have suggested to clients about therapists, like a lot of you said, it's not anything against them. It's just, it's going to help you through the process. And, you know, and I've candidly admitted to clients, when I had my divorce, I wish I had therapy, because you know, you just don't know until you've been there. And, you know, to this day, I'm sure it would have helped, but now I'm all right. So I'm remarried, but it's devastating. And a lot of clients, once you approach it to them that way, like, listen, there's nothing wrong with it. I think everybody could benefit from talking to somebody else and just purging things. So I've gotten a lot of positive response from that, as opposed to, you need to be in therapy. Something's wrong. It's just somebody to assist you through the process. But Lauren, did you have your hand up?
Yes, I was going to say, one of the ways I approach it too with clients is sometimes either saying a therapist is going to help you figure out some of your goals. If you have a client who's changing positions, to say, you know, you could talk to the therapist about your goals, because it's going to be far less expensive for you to talk to that person to figure out what you want than to be changing positions. And then the lawyers or your team now has to figure out, you know, has to change gears. And the other way I approach it too is if they're having conflict with the other party, to say, you need to learn how to deal with this other party. One day the lawyers are going to be gone, the court's going to be gone. You need to know how to talk to this other person. You need to have a better language to create your boundaries with this other person. And your therapist can help you create those boundaries with your soon-to-be ex-spouse. So now you'll be able to move forward. So taking the, you know, not that there's anything wrong with you, but there's some things a therapist could do to help you move forward better.
I like that. Anybody else?
Yes, I had a comment to make as an accountant. When the MHP is fired, which happened on one of my cases, I became the default for conflict management. And as an accountant, that's not something I'm well equipped to do. It was the same fact pattern as you're describing. I thought you were describing my case. They fired one MHP. We tried to bring in another one, and the wife just was not having it. And the MHP actually said, you know what, I really don't want to be in on this case. That's how bad it was. And when they ultimately got what they needed from me, they got rid of me too. But
can I just make a quick comment about MHPs?
I'm sorry?
I'm sorry, can I just make a quick comment about MHPs? And I'm laughing how they did not want one. This is kind of just to put a little levity into it. Years ago, I was asked to do a collaborative case, and some people feel like you're not, I can't explain it. We're either really appreciated, but there's a certain kind of client that views us as, they almost get competitive, where it's like, you don't need to tell me, and I am smarter than you, and I know better, and it's this weird dynamic. And I'll never forget, I was in a meeting and the mother said, well, we have you guys and we'll all meet, and then, and parentheses. And she pointed at me and she called me a parentheses. I can't make this up. And I just, you know, and then what was funny is, like, a week later, there was a catastrophe, and who gets called at 4 o'clock on a Friday for an emergency meeting to settle the case at 5 p.m. Wow. But I'm not sure what that dynamic is. And if any of you have experienced that, where they kind of resent having, maybe they feel like it's a failure on their own part, that they need help. I just was curious if anyone saw that, either not necessarily in MHP, but attorneys or accountants, where there's this weird resistance with the facilitator.
And can I speak?
Oh, yes, yes.
Thanks. To your point, Helen Ann, I think sometimes, even though we explain our role and we're very clear about the distinction between what we're doing in the collaborative process and what we're doing as a facilitator or even a neutral coach, I think that, or an aligned coach, I think that many clients we see have been through marriage counseling and it failed. That's why they're with us. And so when they come to the arena and they know that's what we also do, they're like, been there, done that, don't need you. You didn't help me before. You're not going to help me now. And I think sometimes, not often and not always, they project that kind of disappointment in our profession because we didn't save their marriage. I know that has happened on matters I've been on. You know, wait a minute, I thought you were going to help me. You know, even though they know they're there for a divorce, I think there's that kind of unspoken wish that we can help reason with the other person and get them back together, and we're not doing that. And so they have a bad taste in their mouth about particularly marriage counselors, if you will, and therapists in general. And I think sometimes they come in with that defensiveness.
Anybody else? I can't see everybody's screen, so.
May I, Banda?
You certainly may.
Okay, so I think the chat I said was, I think every member of the collaborative team has an obligation to talk up, you know, say seriously why every member is so important. And one of the ways I sometimes say it, thank you, Aubrey, for the shout out. As I sometimes say it to my client at the beginning is, you know, we can be sitting in this room and I can say something, but if one of the neutrals, the MHP or the financial neutral can say those exact same words in the exact same way, and your spouse will hear it differently. And that's sort of a very concrete way that clients sometimes get why it's so important to have all these people in the room.
Anybody else? Should we be concerned about the number of team meetings at this point? How many generally, in everybody's opinion, what's a good number for team meetings? Or does it just depend on the situation, the facts, parties?
Yeah, I'm going to jump in because I raised my hand and said 5.
Oh, thank you.
But, you know, I like 5 because you have one signing meeting at the beginning where you sign the participation agreement, one signing meeting at the end where you sign all the final papers and get divorced, and then a meeting about children, a meeting about finances, and a meeting about everything else. 5 seems like a good number. But I've never had a collaborative case that only took 5 meetings. And I've had a collaborative case that had 2 actual meetings. That one resolved in 2 actual meetings. There was a whole lot of work done outside of the meetings, but there were only 2 full team meetings. And then I had a collaborative case that had, I think, 11 meetings, because for the first 5 meetings, my client wasn't ready to get divorced and was still trying to figure it out. And when we finally, you know, when he finally recognized, look, we're getting divorced, it's just whether you're going to participate or not, you're getting divorced. Then in the final few meetings, made lots of progress. And then right at the end, client on the other side was like, oh, wait, it's all over. Hold on. How can I delay? And it felt like, you know, trying to delay, and it made for interesting team meetings, wrap up meetings after each full team meeting to say, wait, I thought your client wanted to get divorced. Why are they suddenly asking all these questions? So 5 is a number.
And I see Jeremy said it's not just the number, but the length of time between meetings. And okay, like a situation with Jack and Jill, you think everything's fine. So, you know, everybody's you may not be able to coordinate everybody's schedule. So it may be a little while in between. And then in between that time frame, something blows up. So, you know, it's good point, Jeffrey. Anybody else have any other comments?
Just that the research survey, the data survey, I've been assessing the data. I just submitted a report to Bob. 4 to 6 meetings is the average that we're seeing.
That's interesting.
So Aubrey, you're right. How about it? You know, all the surveys that have been submitted, the average.
Holy, can I quote you? Someone said I was right. Yay!
You can. Yeah.
Anybody else have any comments? All right. So does Jill have control issues? And I think this has already been brought up by a lot of you. Or is it truly a lack of trust on Jack's part? I think a lot of y'all thought it's control just from the chat.
Right,
and what about, yes.
We're just about out of time.
Oh, okay.
So, I mean, you guys are having such a great discussion though. I mean, if y'all want to stay on and continue, but I'm sure some people probably have things scheduled for 1 o'clock. So I wanted to just take a moment and thank everyone for being here and thank Vanda. Wow, you really ignited a great discussion. This was a fun grand rounds. Really, really appreciate it. Guys, don't forget to register for the next Grand Rounds, November 19th, if you're not already. And everyone, if you have any suggestions for future Grand Rounds, feel free to send them my way. I'll get them to Liz and to Kelly. And have a wonderful weekend. And if you want to stay on, we can leave the link up and you guys can continue the discussion.
Is everybody ready to go, or anybody have any other comments? But this, I want to thank all of you because I've gotten a lot of great ideas from all of you. So thank you to everybody.
Great. Thank you so much.
Bye-bye.